Welcome back. Now, The Economist has referred to the resurgence of global white-collar crime as the new age of corporate scandal. Fighting this battle are the pillars of the law, which continue to recognize violated human rights and the need for corporates to pay up for its wrongdoings. On Wednesday, the 10th of April, the United Kingdom Supreme Court ruled that the concerns of 2,000 Zambians over alleged environmental pollution from Vedanta's Zambian copper mine could be heard in a UK court. Joining me now to discuss the judgment and its implications are Danjelle, Midgley, environmental law specialist at the Center for Environmental Rights in Cape Town, and from New York, we have Maysa Zorob, head of corporate legal accountability work at Business and Human Rights Resource Center. Ladies, thank you for your time. I think I want to begin by just trying to understand the importance of the judgment that we have had. Can I begin with you, Maysa? Just how important was this ruling?
Yes, thank you very much, Gottfried. And this really was a critical ruling for many reasons. One, because it represents a watershed moment in terms of ensuring that companies are held to account for the human rights abuses that they commit across their operations and business relationships, because it essentially means that companies who have a parent company that is domiciled in the UK can be held to account for their human rights violations in front of UK courts.
Let me bring you in as well, Danjelle. From your perspective, the import of this judgment and what it means. I have got a slightly different view, but I'm going to share it with you a little later in the program.
Yes, so this is significant. Even though it was a case concerning environmental pollution in Zambia, there are many multinational mining companies that operate in South Africa. And our South African law also has a principle of a polluter pays. So we welcome this judgment, and it does have implications for South African British mining companies as well.
Absolutely. The other implication I wanted to raise, and this is the point that I wanted to make to the both of you, is that we are also talking about a decision which means, in effect, that the law in Zambia might not have been, I don't know the word to use here, big enough, if you like, or credible enough to be able to pass judgment on Vedanta. Does this impugn Zambia's legal system? Can I begin with you, Danjelle, and then we come to the lady in New York?
Yes, so actually the English Supreme Court dealt with this issue of one of the requirements for the jurisdiction is whether substantial justice will be done. Yeah. And this involved an examination of how the courts in Zambia were capacitated to deal with both environmental crimes, but also a claim of this nature, which involved 2,000 applicants. In South Africa, we'd call that a class action, and found that the court system there was not capacitated to deal with a claim of this nature and complexity.
Maysa, does this impugn Zambia's legal system?
You know, Gottfried, I think the more important question is really, and as Danjelle has rightly pointed out, what the best avenue is to ensure that the 2,000 victims in Zambia can have substantial access to justice. And, you know, this really is about a broader question, and that is whether or not the UK domiciled parent company owes a duty of care to the villagers who were affected by the operations of its Zambian subsidiary. And the court has found that arguably they do. And I believe that, you know, the importance is to recognize that there really is a global consensus around companies' responsibility to commit human rights. Yeah. And it is important to acknowledge that this commitment needs to actually be put into action. So it's not enough to use these commitments to polish reputation, but as the court has rightly affirmed, these companies will be held accountable to the human rights and environmental standards that they have set themselves.
Yeah, so perhaps I may not be au fait with all of the legal issues that are at play here, but I wanted to perhaps ask the question whether perhaps it would have been better, or perhaps it's already been done, that the case moves first of all through the Zambian court system before landing up in the UK. In other words, you sue the local company first before you go after the mother. Maysa?
Yes, thank you for that question. Well, actually, both companies are being sued, the parent company and its Zambian subsidiary. And Danjelle has already very eloquently answered the question of whether or not it is likely that Zambian villagers will have access to substantial justice in front of the local legal system. And the court has agreed with the claimant, saying that it is unlikely that they will. So what this really means for companies in Zambia and elsewhere, for their parent companies in the UK, is that they really need to, going forward, carry out due diligence in how they identify and mitigate their human rights risks, how they prevent future risks from occurring, and when harm occurs, that they ensure that they put in place adequate remedy mechanisms to remedy these harms.
Yeah, I imagine, Danjelle, that the other question that will arise, of course, for companies that look at the African continent is that they perhaps may be a little more cautious, if you like, in terms of committing to come in and invest the billions that are required to provide infrastructure on the mining continent and to help also the continent, of course, exploit its mineral resources. Do you see potentially this deterring investment into Africa?
Well, I hope it strengthens the ability of a company to come in and rely on its parent company's reputation in order to obtain the licenses that are required, but to know that there are significant rehabilitation and mine closure duties that are imposed, and that companies should not be able to escape those duties as a result of going into liquidation or insolvency when the parent company is going to be held liable.
Yeah, I suppose also the other point that we should note here is that this is the beginning of a process, isn't it? I mean, we're talking about the acceptance of the case to be had in the UK legal system. The process may well take years. I'm reminded of the silicosis cases here that we saw here in South Africa. I mean, if I remember correctly, I remember coming here in 2001, and this case, I discussed it with the lawyer who was handling it then, and it only got settled, I think, in the past year or so. The potential here for this thing to drag on. Both of you, I'd like your points, please.
Yes, if I could just start there. So basically this case on behalf of almost 2,000 Zambian miners was launched more than 2 years ago. And for it to wind its way through Zambian courts before appearing before an English court, I mean, these people have suffered severe economic and health problems as a result of the toxic effluent. And as you say, this case is on a procedural issue. It's to do with the jurisdiction of English courts. It's not actually a finding on the pollution or the remedies that the miners are asking for.
Absolutely. Maysa?
Yes, thank you for that, Danjelle. And I agree with these points made. What perhaps I would add is that in addition to these lawsuits that are brought in the UK and elsewhere against parent companies domiciled in these jurisdictions, there's also an important movement going on globally in terms of introducing new legislation that would require companies to exercise due diligence in identifying, mitigating, preventing, and eventually remedying human rights harms. One example of such legislation is the recently passed due diligence law in France that would require companies to exercise this diligence. And other legislative proposals have been made in Switzerland and elsewhere, and even at the global level at the UN, these discussions are ongoing. Yeah. So it really is part of a broader movement to ensure that communities everywhere in the world have access to meaningful justice.
Yeah, it is very interesting as well because, as you say, due diligence ought to be done. But I can't remember exactly when Vedanta got these mines, because these mines used to be owned by Anglo-American, then a South African headquartered company, which now is a UK headquartered company. And I'm wondering whether there's any liability or potential liability here to pass on to the company that sold the assets to Vedanta. Can I begin with you, Maysa?
Well, I think, that is for the lawyers of the case really to figure out where and by whom the liability lies. I think the broader question, and as I've mentioned earlier, what is important is to ensure that the victims of corporate human rights abuse really have access to remedy and to meaningful justice. And that is what the lawyers all over the world, and the lawyers in this case from our partner law firm in the UK, Lide, is trying to achieve.
Yep. Danjelle?
Yes, you raise an interesting issue and something that South Africa is also grappling with when there's an ownership in a mine. it's often where liability gets lost. And it will be regulated by both the legislation and the contract where the ownership of the mine is transferred. And as I say, this case is just a first step in recognizing jurisdiction. The next step will be for actually the pollution and the effects on those miners and community members to be proved in court. And then as both the parent and the subsidiary company are being sued, there'll be a discussion of which company will be liable.
Yeah, and perhaps would I be wrong in trying to extrapolate this and saying that what this does is open the doors to potential legal action from any part of the world where a multinational is operating? Say, for instance, you've got a company that is operating in Kenya that is now being sued by Kenyans, and that this case could potentially almost automatically, if you like, head to the UK, because in law this has been established to be possible. I don't know who is the right one to answer this one.
I mean, perhaps I could start, Danjelle, if you don't mind. Well, I think what's important is, yes, this could potentially, I mean, it sends a strong message to companies all over the world that they must carry out the due diligence, human rights due diligence we were talking about earlier. But the UK court has also made clear that, you know, claimants bringing these kind of claims need to demonstrate that that jurisdiction, in this case of the courts in the UK and Wales, are indeed the right courts to bring those cases. So claimants must demonstrate that they are unable to obtain substantial justice at home, and they must also demonstrate that the parent company that they are suing has a duty of care towards them. So it is not quite as automatic, Gottfried, as you were saying, but certainly this is an important step in the right direction to ensure access to justice for victims of corporate human rights abuse.
Yeah.
In
Danjelle,
Africa and elsewhere.
Yeah. Danjelle, you want to add?
Yes, so I think there is still a factual inquiry that must be made as to the nature of the relationship between the parent and the subsidiary. And in this particular case, in Vedanta, the claimants were able to establish that the parent company basically exercised sufficient control over its subsidiaries, so that in this case, the company had been structured so that the parent company was able to implement, for instance, environmental or sustainable policies across the group. So it's not across all holding companies, but that will have to be a factual inquiry made into specific mining cases.
Yeah, indeed, there may be well-specific factors that will lead to different outcomes in different cases. Ladies, thank you very much for joining us today. Danjelle Midgley, environmental law specialist at the Center for Environmental Rights, and Maysa Zorob, head of corporate legal accountability at Business and Human Rights Resource Center. Thank you for joining us. And that's where we leave it today. Thank you very much to all my guests on tonight's edition of Capital Connection. Join us again every Monday and Wednesday at 6:30 p.m. Central African time for today. Thank you and good night.